Good morning, everybody. This is my project for the contemporary legal issues. I chose the case Mattel versus MGA, pretty much the Barbie versus Bratz case. Just wanted to show you a couple dolls first. So this is a regular Barbie doll. She's seen better days, obviously, her hair and clothes, but regular Barbie doll. She's had some changes that Mattel has gone through. This is actually a really cool one. She's like one of the realistic size Barbies. We like these. We like these too. So keep an eye. This one here is not a Bratz doll. This is a LOL doll. I don't have any Bratz dolls. Well, my daughter doesn't have any, but this is somewhat similar, but I just kind of wanted to show you the difference. It is very similar to the Bratz doll. Big eyes, oversized head, pouty lips, kind of racy clothes. Very different than Mattel's Barbie. So just wanted to give you guys a visual of that. Again, this is not a Bratz doll. This is an LOL doll. I just wanted to show you guys kind of for reference so that you guys can see the difference. MGA is a company that is producing the Bratz dolls, and Mattel obviously produces the Barbie dolls. Mattel discovered that the mind behind the Bratz dolls, Mr. Carter Bryant, was at one point their employee, and he was a Barbie clothing designer. He actually pitched the Bratz doll concept to Mattel, but they did not go with it for whatever reason. And then Mr. Bryant went and he started working for MGA, and he pitched that idea to MGA. MGA ran with it, and they created the Bratz dolls that we now have all over the stores. Kids love them. I know my kid does. We don't have any, or we had, but they fell apart. But they're pretty cool. They're very diverse, which we love. Their clothes is really cool. They have really cool long hair, so you can cut the hair and not worry about it, being super duper short. My kid loves these dolls. They're pretty successful. In 2003, they brought in over $1 million in doll sales alone, just Bratz. So just to give you an idea how popular these dolls are, and I guess why Mattel wanted to get their intellectual property back. So that's a little bit of a background from what I looked up as far as the allegations and arguments go. Mattel was suing both Mr. Bryant and the MGA company, claiming that Mattel owned Bratz as intellectual property and was seeking an injunction to stop MGA from selling and producing the Bratz dolls. They were claiming that Mr. Bryant's idea for the Bratz was in fact Mattel's intellectual property. As far as the resolution goes, the outcome of this case, it's kind of a long one, just because there is a lot of issues with it. They went back and forth. I believe it was over a decade of litigation. But I'll try to be brief, kind of in a nutshell. According to aegislaw.com and also according to michiganitlaw.com. There are two sources that I went online to review this information, and then also another website, a legal website to check for cases and whatnot. Mr. Bryant settled with Mattel before the trial, but Mattel continued its lawsuit against MGA Toy Company, accusing it of stealing Mattel's intellectual property. A federal jury agreed and awarded Mattel, this is the first case, okay, guys? They awarded Mattel $100 million in 2008, and the district court ordered transfer of property to the rightful owner and issued that injunction that Mattel was seeking, preventing MGA from marketing and producing Bratz dolls. So then the U.S. Court of Appeals for the Ninth Circuit reversed the decision and then remanded the case for a new trial. Okay. And then one of the Ninth Circuit rulings held that the employment agreement was ambiguous. Ambiguous meaning that it was not clear. It held several meanings. And the jury should have been allowed to decide whether the agreement assigned Bryant's ideas to Mattel. Specifically, the court found Bryant's employment agreement ambiguous because whether the idea of the new doll fell within the definition of an invention as mentioned in the employment agreement was unclear. The court also found whether or not Bryant created the Bratz dolls during the scope of his employment to be unclear, also again ambiguous under the employment agreement. In the new trial, Mattel lost. The jury did not agree that Mattel owned Bryant's idea. Yeah. So as far as the legal elements go, intellectual property, copyright, unfair business practices, the element of intellectual property and how Mattel failed to lock down the wording on the document that protects the company's intellectual property. Had they done so, they could have had billions of dollars. So again, the jury stated that Mattel's contract was ambiguous, meaning it was open to more than one interpretation. It was unclear. So, in closing, I guess a lesson, something that I learned from this is that if you have a company and you have your employees and you're in the business of creating things, you need to make sure that your employee contract or confidentiality contract, whatever you want to call it, is ironclad, and that your trade secrets won't go with that employee after termination of employment to another company and then have them profit. So it needs to be ironclad so that this won't happen. Had Mattel done this, they would have saved hundreds of millions in legal fees. According to my sources here, both Mattel and MGA both spent well over $100 million during this case, during this decade. So had Mattel just gone the extra mile and done their homework, secured their contract, they would have never been in this situation. And MGA right now is laughing all the way to the bank because their dolls are doing amazing. So thank you guys. I hope you guys enjoyed that. I know I learned some information. I had no idea that there was drama between the toy companies and how much money was actually involved. So this was pretty interesting. Thank you guys.